Roger.
Yes, my question is probably for Dan Troy. Given the egregious facts in the Wyeth case, it raises the question, what's left for the FDA? I mean, there the nurse ignored no fewer than 6 warnings, administered a double dose of the drug, leading Justice Alito to conclude that the majority on the court had bootstrapped an ordinary medical malpractice case into a frontal assault on FDA warning labels. And it leads to the conclusion that no matter what untoward result eventuates, the warning will be found wanting. And so what is there left for the FDA after Wyeth?
Well, it's a reasonable question, and it gets to the point I was trying to make, that while the FDA, the court talks about two things, right? It talks about that the manufacturers are in full control of their product labeling. You know, it would be interesting to ask an FDA reviewer off the record what they really thought of that, because I don't think they would agree with that. They view the labeling as essentially their real estate. And we propose, they dispose, and if they want us to say something, guess what? We say it. And if we don't, then they can come after us for misbranding. So there's that point. And then again, lawyers often, and the court, Justice Pryor in particular, talked about the FDA as if it's making, I mean, of course, because it's an agency that operates under law, the decisions it's making are legal, but the day-to-day scientific interaction between scientists at the agency and scientists in the company, to expect that to have the kind of process that is going to be A, open and transparent, and B, lead to pre-regulatory and preemptive effect is unrealistic and never going to happen. So, as Catherine said, we find ourselves in the horns of a dilemma. I do hope that post-Wyeth we can win cases like Colachico, like the generic hypothetical that I posed, where the agency tells us exactly what to do and what not to do. But there was actually some debate within the pro-preemption, pro-innovator community about whether or not Wyeth should go up or they should wait for Colachico, because they thought that Wyeth was actually too easy a case, which tells you what you, maybe that's the rebuttal to what Paul Clement said about Supreme Court advocates.
Yeah. Okay. Mike Rossman.
I have a quick question for Dr. Greve. Did you try in your analysis to ever break down the preemption cases between conflict and field preemption? Are there any justices who are more predisposed to one rather than the other?
We toyed with the idea and decided against it because you're dealing with a very small number of cases. Therefore, every coding decision you make has a very big effect. You try to slice the salami that thin. The potential errors and the debates over which case belongs where just overwhelm you.
Michael Wallace.
I told Alan before lunch the only thing my clients care about preemption is whether it will get them out of the courts of Mississippi. But standing contrary to where I sit, my question for the panel is, why should it? If the federal government wants to disable local juries and local voters from making decisions that they've been making for 200 years, shouldn't they have to say so in terms that nobody can misunderstand? You've got a clear statement rule in 11th Amendment law that says if Congress wants to put a liability on a state enforceable in federal court, they have to say so in absolutely clear terms. Is there any problem with the presumption other than the Supreme Court hasn't said, we really mean it? If you don't say in so many words we're preempting, then you're just adding rules, you're not replacing any.
Well, Mike is offering me a great gift, and I shouldn't turn it down. It certainly ought to be true at the regulatory stage. But I think we have to be realistic, and as much as I would like that, at least in 75% of the cases, to have that in the congressional stage, I just don't think it's realistic to expect Congress to make clear statements about a whole range of issues which they can't even reasonably expect to think about in the same way that are going to arise in the real world, being a very complicated place. So at the regulatory level, definitely, and at the other level, at least you ought to have some indication that they intended not only to affect regulation preemption, but also tort and compensatory damage preemption. Because a regulatory preemption, you're just simply telling the state agency they can't do it. You're not depriving somebody of compensation to which they would otherwise be entitled, assuming that they had a valid claim.
I guess I would make a plea for the realism principle that I agree that Alan is properly applying to Congress, to the state, to the agencies as well. I guess the point I'm trying to make is to expect every regulatory decision that in the real world does have, and I would argue normatively should have, preemptive effect, to expect that to be accompanied by a clear statement rule is as chimerical as expecting that the Supreme Court, that the Congress is going to do it when we'd like it to. You're simply not going to get regulatory scientists making decisions about what should and shouldn't be in labeling just on a product-by-product, day-by-day basis to make specific findings that this decision should or shouldn't preempt state tort law.
Just want to add something to this, which is sort of partially agreeing with Michael, but for the most part, no. I don't think it's right to describe most the sort of run-of-the-mill preemption disputes where they come in contact with state law as displacing the kinds of judgments that Mississippi juries have been making for 200 years. I mean, most of these things are rather more modern and unconventional and untraditional forms of tortious liability. And they have more to do with, so I mean, you can describe the same actions under two different labels, right? It's tort liability, and so therefore it's traditional state power. Or you can say, well, it's just a sort of tort substitute for the regulation of national commerce, in which case it's decidedly non-traditional what they do, and there's no reason for a clear statement rule at all. I'll say this much in agreement with you. It is true that preemption doctrine in the modern universe is made to do an awful lot of work for which we formerly had totally different doctrines, right? All those doctrines have gone by the board, and so now the only thing that's left standing is the preemption doctrine, and so you crowd, I mean, the courts and theorists and legal scholars crowd all of those sort of federalism concerns that once upon a time were handled under very, very different labels. Extraterritoriality, right? You had sort of pre-Erie rules of choice of law and so on and so forth. Under those circumstances, I'd be much more open to these kinds of federalism arguments. Now that all of that is dead and gone, and this is the only horizontal federalism doctrine that's still on the books, with the exception of the Dormant Commerce Clause, which is also on its way out. No way, I'll hang on this doctrine whatever I can.